Thank you so much for coming to our nation's first ever age-friendly festival. It's a community gift given from the Patterson Foundation, and we are just so lucky to have as many things as we've had today. It's really, really great. And the whole purpose of the festival is to bring our community together. So as we age, we're living longer, that we age well, that we stay active and vital in our community. That's so important. Our next session is Life Happens. Prepare now to reduce one's stress. Whatever your age, learn about key decisions and documents that will reduce stress for you and your family. And I want to present Roseanne Frano. She is a attorney at Williams, Parker, Harrison, Dietz, and Getson law firm. So thank you, Roseanne.
Thank you, Shana. So good afternoon and welcome. I am Roseanne Frano, and I've been practicing with estate planning and estate administration law with Williams Parker, which is right downtown Sarasota, for about 15 years. And this topic and this festival is so interesting and wonderful to kind of highlight all the parts of our community that really come together for the entire span of your adulthood, from young adulthood into advanced age, and all the topics and challenges that intersect throughout that. Life happening is one of those things that intersects from young adulthood all the way through advanced age, and what I'm here to highlight at a very kind of at a surface level, but with very important focus, is that setting up an estate plan, which means making decisions and legally documenting those decisions so that if you're ever able not to communicate on your own, be it during lifetime because of incapacity or a health issue, or after death when your estate is being settled, making sure that you've really set forth plans clearly and carefully and with legal authority so that others will be informed and knowledgeable and able to carry out your wishes. Because in those moments when you can't speak for yourself, you really want to make sure that who is speaking for you really understands you and what you would intend. So with that, I went backwards. Here we go. The basics. So with an estate plan, when you're making decisions about who will be assisting you carrying out your wishes and what those wishes are, it's very important to plan ahead. That's one of the points of today in thinking through the age-friendly festival. From when you're young to when you're in the middle of your life, raising families or growing a business, or more advanced in life, your most closely held values and priorities are changing and growing and morphing. And as that happens, it's very important that you reconsider all of these important decisions. So as far as basics, what I've highlighted is work with an attorney. This is not self-promotion. What this is a statement that it's really important that if you're not there to communicate on your own behalf, that whoever and however you've appointed someone else to do that, that it's legally effective. You want the bank to accept the document that somebody is presenting to be able to pay your bills. You want the doctor to accept the document that you're presenting for somebody else to make a medical decision on your behalf, to accept that form. So working with an attorney is important, and it's important to have all of your trusted advisors work within that planning to make sure that your decisions are being carried out. Also, take time. These types of plans, they change and grow, and it shouldn't be something you do once and never think about again. But you're making very important decisions, and those decisions aren't always evident at the first time that you think about it. So you want to build in time in your process to think about your decisions, dwell on your decisions, struggle with the hard decisions, rethink them, maybe talk to somebody else who's a trusted person in your life that you really appreciate their perspective, or that you may be asking to take a role in your planning so that they can know, again, your perspective, your decision-making process to be able to carry out your affairs. The real win in an estate plan and planning for these unexpected moments in life really is if you have confidence that your plan is well laid, well considered, and constructed in a way that it'll be effective, and confidence with your loved ones that you've created this plan that works and that they know what to do and when and how to take that first step of helping if it's ever necessary. So, and I forgot I put the third bullet point. This one is self-evident, but once you write your estate plan, once you sign documents, the lawyer has signed off, you've got your notary stamp, and it says what to do, store them somewhere safely. We don't want to have the coffee spilled on them at the dining room table. Somebody needs to know where they are, how to access them, and when to look for them. So we'll go on. I'm going to go in a little bit into the details. So there are 2 periods of time that you look to when you're doing this planning. And so the first time, of course, is during your lifetime. So we're thinking about times that you are living and unable to communicate your own decision, unable to sign your own name to a legal document for any reason. This could be that you're out of town, literally can't get there to sign a document, or it could be that you are incapacitated and unable to make the decision that's necessary. So a durable power of attorney is a really important document. This is only effective during your lifetime, and what it does is it gives legal authority to somebody else to sign your name for you. This is a big deal. This is everything. This is moving money out of your checking account, putting it in your savings account, managing your investments, selling your house, mortgaging your house. When you have a durable power of attorney that is not limited, it's broad, it's important. It's intended to be broad because you want somebody to be able to exercise their judgment to make a decision that they think is in your best interest based on what they know that you would do in that situation and what's best for you. So the word durable is important. The word durable means that it survives your incapacity. So you sign it today, and that at some point you're determined to be incapacitated if that were to happen. This power of attorney, this person you've given legal authority, can still act on your behalf. There are limited powers of attorney that says this person can only do one thing for me. There are powers of attorney that are not durable that mean if you become incapacitated, there's a new document or a new process that takes over. So in this case, thinking about a durable power of attorney is really about giving somebody that authority to manage your financial affairs. How you pick someone to be in this role is very hard. I mean, this is trust. This is really putting it all out there and saying, I have implicit trust in this person, not only that they're going to be looking out for my best interest, but they're capable of performing this role. You really want to think about who has time and ability, who has the same business judgment and acumen that you have, who has common sense in the way that you have it. It's really choosing a person to stand in your shoes and say, I know they're going to make the best judgment that they can, and that's okay with me because I really trust that they're going to do a good job in this role. We're going to talk in a few minutes about if you do not have a power of attorney. In a lot of ways, the law provides defaults. If you haven't named somebody to sign your name for you, it says who that person is that the world and the law looks to first make that decision. With powers of attorney, if you do not have one, they look towards the guardianship process that I'll talk about in just a few minutes. Healthcare Advance Directive and Living Will. This is similar to what I just spoke about with the power of attorney. It's sometimes called a medical power of attorney, a medical proxy, a healthcare surrogate. There's lots of ways to describe it. It's a document that gives somebody authority to have access to your private health and medical information and someone to make decisions for you if you are not able to do so and not able to communicate to the doctor at that time. You can set the kind of the scope. When are they allowed to have access to information? When are they allowed to make decisions for me? Who's the first person in line and who's the second if the first person's not there to be able to make that decision? It can include all the small decisions, making appointments, getting a test result by phone for you, something like that, where all the HIPAA rules prevent doctors and hospitals and physicians sharing that information. This document can allow someone to get that information for you. But it can go as far as the living will, which is really an end-of-life decision. Do you or do you not want artificial support if you've reached a condition that your life would not continue without it? And under what circumstances? Do you want organ donation? All of these things, they're not fun to think about. They're not fun to talk about with your family. But the nice part is that once you go through this thought process and once you have this conversation with your family, it can actually be, at the end, a very positive and uplifting conversation because you're back to that idea of confidence. You have confidence that people know what to do to carry out your intentions and what your most important priorities are. It also gives them confidence they know what to do and where to look. If you do not have a healthcare directive in place, you haven't named someone to make decisions for you, the law does provide almost a pecking order, starting with your family and going from there on people who make these decisions for you. it's always better to make your own decision than let the law do it for you. So this is one of those lifetime documents that really is important. I'll just highlight briefly, depending on how your family's structured and if you have minor children under your care, there are medical powers of attorney that you as a parent or as a guardian can provide to allow someone else to make these decisions for your children. These are not nearly as common, but if you're leaving your child in the care of somebody else for a weekend, this may be something that you want to think about. Or if you're taking your grandchildren or taking somebody else's child and you want to think about what happens if they fall at the playground and break their arm, what do I do? This is one of those documents that their parent should be considering for that time period. Guardianship is a process that gets a lot of press coverage, and it's not always good, and sometimes it is. It's a legal process. It's a different animal than what we just talked about with powers of attorney. So when you think about lifetime documents, these powers of attorneys are you making a decision. This is the person that I give legal authority to make decisions for me if I cannot. Guardianship is a process where the court appoints someone to do that for you, either because you haven't and there's a need for this decision to be made, or that there's something going on that legal process is necessary to sort out. And it's an ongoing process. The court appoints the guardian, and then the guardian reports back to the court at different intervals. If you are a guardian of the person, that means the medical decisions. Well, the guardian's reporting back to the court of your well-being and your health and things of that nature. If you're a guardian of the property, you're doing the same thing on the financial side. And so it is truly a legal process. When you have legal documents in place, you may not need this process. And I'm just highlighting the difference there, that one is something that you do once. If you're under this guardianship procedure, then it's an ongoing interaction with the court. So there is more cost, there's more people involved. It's good for what it does and when it's needed, but you can control whether it's a needed process by taking time to establish the documents and put them in place. So we've talked a little bit about lifetime. So this is you're living and you're unable for whatever reason to make a decision or carry out an action. Who does that for you? Here with the last will and testament, we've transitioned to the other side of the line, which is after a death. How is someone appointed and how is someone to know how to carry out your final wishes as to your estate administration? So the powers of attorney that we talked about, those are effective during lifetime, and at the time of your death, they're done. They're no longer effective because you're not living, you're no longer able to give that legal authority for somebody to act for you. Well, after a death, when you go to the will says, here I nominate my personal representative. That's what we call an executor in Florida. And again, this is a legal process where you go to court and you have this executor appointed, and then they go through and they carry out your affairs. When you think about your will and this idea of reducing stress, what's the idea of the will? You want it to be clear, concise, thoughtful, legally effective, to outline your wishes, your hopes, and any instructions that you want to leave behind. So the will is really a blank slate. It needs to cover some things, but it can cover anything that's important to you. So it needs to say who pays taxes, how, who pays your last debts and from where, all of those very practical things that happen. But then it really is a blank slate. You can say who inherits and what are the rules around that. If you have young children in your estate plan, do you want them to inherit at 18 when they're legally an adult, but perhaps not an adult, as we think about it, with responsibility and a good judgment to inherit? Who's going to help manage that for them during that time period until they age to a point of maturity that you feel comfortable with them receiving an inheritance? If you have special needs members in your family or your circle, all of these things can really be written out into a last will and testament. You can apply conditions, instructions. They can be descriptive. They can be very simple. I leave everything to my spouse, if not to my children. But the idea is you want to be thoughtful. You want to work with a lawyer, and you want to think back and say, okay, let's go one step further than what makes sense to me. So it's most likely that everybody's going to survive me, but what about in that odd circumstance? Is there a charity that I love or a religious institution, whatever it is? You really want to have a thoughtful process that's not just your first instinct, but one where you reflect on it You think about your decisions, you think about who you've put in positions of authority and who you've put as positions of beneficiaries, and come to a point through that consideration and dialogue that both your mind and your heart and your gut instinct all kind of line up and say, this is a good plan and I feel good about it. And then you make sure that it's legally effective through the process of working with an attorney and other professionals so that you can be sure that it'll be carried out. I've highlighted, and I'm not going to go into detail with trust, but oftentimes in Florida, people incorporate into their traditional estate plan a revocable trust. Revocable, the first word in the top bullet there, versus irrevocable. Irrevocable means you can't change it once you do it, and it's a totally different instrument. It's for gifting. With a revocable trust, it's a much like a combination of a will and a power of attorney mixed together. But it involves only the assets that are owned in your trust. You never just have a trust. You'll always have a revocable trust and a will and a power of attorney, because you really need them all to come together to be able to carry out your wishes in all circumstances, both anticipated and unanticipated. Safekeeping of documents. So I mentioned this at the beginning. It's hard to know where to put these things, especially we live in a state where there's hurricanes and every other thing that goes on. What's most important is that you feel comfortable with how you've decided to store your important estate planning documents. Some people have them in a safe at home or in a file drawer, and they tell their family or their trusted advisors, look for the green folder. I've put everything in a green folder. If something happens to me, go get it. It's in the top drawer. Whatever it is that gives you a sense of security with the documents and that you're not going to spill things on it or accidentally throw them away or shred them. That's important. Some people put them in a safety deposit box. That's fine, but you want to think about who can get in that box other than you. If you're in a position that you're not able to act and you're the only person on the box, it's going to be hard for someone to get the authority to go access the box. So there are lots of considerations into it. People keep them at their attorney or CPA's office. But just make a choice that feels good to you, that you feel secure with it. Make sure somebody knows where they are, and make sure somebody knows who to call if something happens, so that they say, I'm going to go get the documents, but then I need to call Roseanne to say, what do I do now? Or whoever it is that really would be that informed person to be able to help. There are a lot of electronic storage programs that are out there and password protection programs. I can't opine or really comment on any of those, but they do exist. The important part is that, like the safety deposit box, if you've set things up in an electronic way, somebody has to be able to access it and know how to access it. So don't forget with computer passwords and whatnot, as you think through safekeeping of documents, that it's also important that you have somebody, again, who can access things. So in a nutshell, with estate planning and planning for life's unexpected moments, the real takeaway is that you want to make sure that you work with a lawyer to create something that's legally effective, but that's custom to you, and it's custom to your family and your loved ones and your circumstances. It doesn't have to be elaborate, but you really want to have something that says what you want to happen, who's making those decisions if you can't, and then also communicate with that person about what's most important to you so that they really feel confident in making those decisions, that they know they're doing what you would want them to do and they feel empowered to do that. So I think, thank you.